Okay. This short session is to explain why I will not be teaching constitutional law next fall. I know that I was asked to teach constitutional law at the in the fall as an undergraduate political science, pre-law, whatever course. And I know many of you signed up for it thinking I'd be teaching it. I won't. I can't because I don't know what to teach. I don't know how to teach constitutional law when there is no such thing anymore. All we have now is whatever at least 5 of 9 people sitting in Washington, D.C. tell us to do. It can't, it's a constitutional something, but it's not law. Those of you who've heard me say law is interpretation before, and those of you who've been with me when I explore how seeing law as interpretation exclusively, entirely, all the way down, which is the position I take, all law is a process of interpretation. You've heard me talk about that and how it matches up with the concept of the rule of law. And to put a very simple point on it, law is all interpretation, but interpretation is not purely arbitrary. To be law, the interpretive process must fit certain norms. There's there's legal interpretation, and then there's just whatever. Whatever someone in a black robe chooses to say. That's not interpretation, that's just arbitrary exercise of individual power. I've spent a lot of time exploring what I mean by interpretation. But right now, currently in the United States, the final word on the Constitution rests with a court made up of 9 individuals, several of whom no longer even pretend to be doing law. Though they do pretend to be doing law, but not very hard. They're not pretending very hard. They call themselves, for instance, originalists and also textualists. They care about original meaning and the words in the text, et cetera, et cetera. Actions speak louder than words. It's clear that the words in the text don't mean very much to these people, nor do the intentions or purposes behind those words. And, I get there's a lot of controversy about what I even meant by that last statement, but whatever you mean by the purposes or goals behind the words, they don't care about them. Decisions interpreting the Second, Ninth, and 11th Amendment establish that beyond any doubt. The words mean nothing, and the goals intended to be reached by those words mean nothing. Stare decisis, precedent, history, legal history, decisional history means nothing, which they've thrown the common law process completely out the window. So we don't care about the words, we don't care about precedent, we don't care about stare decisis. Logic doesn't mean a whole lot because logic demands consistency and coherence. Consistent and coherent explanation is not particularly relevant to them. What is? Well, nothing that counts as legal interpretation. Certainly, ideological concerns matter, but that's not legal interpretation. Without stare decisis, without any concern for the text, without any attempt to understand the meaning of the text, without any real effort to be logical, coherent, or consistent. It's just arbitrary, whatever I say because I'm the boss. And that's where we are right now. There is no constitutional law. There's just whatever I say. But this is a self-destructive process, as these radically conservative ideologues who sit on the Supreme Court will discover. Because if nothing counts, no words matter, their words don't either. And if everything that came before can be ignored, well, so can what they did. It can be ignored as well. But that's why I won't be teaching it, because I don't know. There doesn't seem to be anything left to teach. Thanks.